My Lords, just two bits of housekeeping.
Yeah.
First of all, with apologies again for the miserable state of your Lordship's authorities bundles. Hopefully that's been rectified in the shape of some spines which are actually of assistance to your Lordships rather than as false friends. That's the first thing. The second thing is my Lords asked for the references to two judgments, the recusal judgment of the Court of Appeal in the East Caribbean and the discharge judgment. The recusal judgment is to be found, I'm not going to go to it.
No, I just needed the reference.
No, that's very kind, thank you. It's tab 64 of the supplemental bundle at page 958. There's the recusal judgment.
Thank you.
And the discharge judgment is tab 79 at page 1350. Which your Lordships will find at volume 3, the other one at volume 2. Yeah. Those are the two bits of housekeeping I think I needed to attend to.
Thank you very much.
I go back to the question of risk of dissipation against Mr. Gollitz, and I should say that essentially we rely upon 4 pillars, and I'm currently in the first pillar of risk, and we are looking at the document. I think we were looking at the document at page 170.
Would you like to tell us, just as headlines, what the 4 pillars are?
Oh, of course. The 4 pillars are, 1, this letter and the way that Mr. Gollitz sought to explain himself thereafter. And there's a slightly elaborate history to that, which I'll elaborate. Pillar 2 is the nature of the allegations made within the substantive proceedings and the fact that they are now, with the new documents, substantiated to a high degree. Pillar 3 is the fact that Mr. Gollitz, I regret to say, has been established now to have told multiple untruths, we say, in his witness evidence before the court below, as demonstrated by the new documents. Pillar 4 is an amalgam, but it essentially is founded on the fact that Mr. Gollitz has falsely alleged that he has no financial connection to CSM, whereas in fact we say now the evidence shows that he has a hidden connection to CSM and has, we don't know the full truth of it, but there are at least substantial glimpses of how he is paid out by CSM. Possibly, and possibly more than possibly, probably, to the ignorance of his own employer. But we'll look at that. So those are the four broad pillars. I deal with pillar 1. We're at page 170. Here's the letter, which we are at paragraph 3. Worst comes to worst, I was informed by our fund administrator and auditor that there have been recent regulatory changes, and your Lordship have seen that paragraph before. Just note, though, that apparently Mr. Gollitz has had this fact of a recent regulatory change from 2 separate sources, one of which is a professional person, the auditor. It is clear that Mr. Gollitz recognises the enormity of the request he is making and the extent to which it strikes at the very heart of the joint venture. See at the bottom of the page. This all came as a total surprise. I have no choice. And then over the page at 171, this is not just a regular transaction. I'm withdrawing some funds, I'm bringing some other funds in. It's all in a day's work. I am very sorry, and your Lordship can read on to the end of that page. And, of course, it's in bold. It is quite clear Mr. Gollitz realises that this is a cataclysmic moment in the relationship between his company and my client, and in the relationship that has been founded upon the joint venture we see evidenced in those 2 written documents which I mentioned before the short adjournment. Now, it is common ground that that was a false statement at paragraph 3. But it goes worse than that. It's not just a false statement that there have been recent regulatory changes. The falsity is even greater because he has identified the source of his information, fund administrator and auditor. We're going to come back to how he explains himself in the evidence. But, my Lords, there are 2 further communications that occur during that very short window of time at the beginning of December 2020. I'm not putting them in particular chronological order because there's a dispute as to when the conversation at page 172 occurred. It doesn't matter for these purposes, but it's quite clear from a reading of the recording at 172, which is between Michael, Adam and Nasser, Gollitz, Duffy and Tahir, that the notion that this is a recent regulatory change is being persisted in, but that is then made abundantly further clear at page 178, a yet further communication from Mr. Gollitz to Mr. Nasser Tahir, where this is obviously written after the call they've had, which I think is the one we looked at, which is in the transcript just preceding. Yeah. And again, the persistence in the idea that the need to sell the notes is because of changes in the regulatory requirements, paragraph 2. So this is not just a little mistake in a letter which is sent in a normal day's work. The very foundation for the destruction of the joint venture is recent regulatory changes. I'm so sorry, Mr. Tahir, it's beyond my power because the law has changed. Now,
the reference to your the approach you suggested did sound nice, was to reversing the trade.
That's right.
Which is what he says in the call. So it's perfectly obvious the call had
preceded that email.
Had come between the letter and the
yeah.
And this email.
I think there may be a minor dispute, but it's of no moment as to whether the phone call took place before the first letter.
I understand.
But I don't think that it affects my submission.
December, yeah.
Yeah. My lords, that is now accepted to be wrong, what Mr. Gollitz said on those 3 occasions. And Mr. Gollitz put forward an explanation for that in his second witness statement, the one which we've spent so much time on, which is in the supplemental bundle. We're going to go back to it again if you don't mind. It is tab 107, and we're now at page 2041. I think it's in the 3rd volume of your Lordship's bundles. I'm taking this as quickly as I can, because I've got limited time, of course. My lords, yeah. Page 2041, para 53, is where Mr. Gollitz deals with this. I'm conscious, he says, that in my letter to Mr. Nasser Tahir, I said that this issue had arisen as a result of recent regulatory changes. That was incorrect. The relevant provisions had been in force at all material times. The reason I expressed myself in this way was that I had misread or misunderstood Mr. Preece's email. Just pausing there, Mr. Preece is or was at least, the director of VDHI, who also gave evidence in these proceedings by way of his own witness statement. So what is being said by Mr. Gollitz at this stage in his evidence is it was wrong, but I made the mistake because I misread Mr. Preece's email. And your lordships will think, well, what did Mr. Preece say? So let's look at that. That is, I'm afraid, I'm going to have to invite your lordships to pick up another bundle, bundle 1 of the supplemental. And to tab 19, page 179. In fact, your lordships were there just a second ago.
Yeah.
And we are now in an email chain starting at the top, the 4th of December 2020, from Michael to Adam, Michael Gollitz to Adam Duffy. And the email, and this is common ground, the email that's being referred to at para 53 of the witness statement is the email at the bottom of the page, where, although it's sent from Brandl to Gollitz, it is an email from Price, because we see that. Good morning, Mr. Gollitz. And then I just wanted to briefly show you something, explain why it's so important. And then we have over the page the receipt of the letter from CSSF, which we have the full document somewhere else in the bundle. Best regards, Olaf Preece. And it's being said on the 16th of November in the witness statement placed before Mr. Tinkler. The reason I made the mistake is because I misread at the time, that's when he was doing the misreading, the email at 179 of the bundle. Now, we looked at that, or not me because I wasn't involved at that stage, my clients' lawyers looked at that and said, well, that can't be right. The Preece email is dated the 4th of December. It's after the balloon goes up, after the cataclysm. And we pointed that out to the lawyers acting for the VDHAG and Mr. Gollitz. And Mr. Gollitz had to come back a third time or a second time. And he put in his fourth witness statement, which is in the bundle at tab, it's the third bundle, it's page 2779, and I'm afraid I haven't got it's almost the last page. Do you want the tab number? It's 2779. Forgive me, my lords, my note doesn't give me the tab number.
2779.
2779, it's the fourth witness statement of Mr. Gollitz. It's his final utterance in the court below. I do apologise. Thank you, my lords. If you go to paragraph 2, sorry, I'm going quickly.
Yeah.
Paragraph 1 is conventional stuff. Paragraph 2, I'm addressing the error I made at para 53, where I said I'd taken it from an email which actually was dated the 4th. Then para 3, I misrepresented the chain of events. It gives some purported explanation for that. And over the page, 4, the fact is that I had thought there was a change. I must have had that from somewhere, but I don't recall where I had that idea from. That's what he says in his fourth witness statement on the 11th of December of last year, just before the hearing commences before Mr. Tinkler. Now, that doesn't make any sense. A, he's made a blunder in his witness statement, his second witness statement, which, given the enormity and the importance of that document to the case, might be thought to be remarkable in and of itself. He's then had that error pointed out to him. He's been caught out, and he's now, instead of offering a proper explanation, he's now saying, "Oh, I just don't remember now." But the question, the burning question that remains, if one goes back to the letters that were sent on the 3rd of December, is that he is saying positively there to my client, I had this information from 2 sources, the fund administrator, that must be VDHI, but also a professional person in the shape of the auditor. It's inconceivable, my lords, that an auditor would have given him such false information in early December. And no attempt has been advanced or made by Mr. Gollitz to set out who the auditor was, ask the auditor, or to ask Mr. Priest, who gave evidence himself within the case and doesn't support the evidence of Mr. Gollitz. So, my lords, I could spend rather more time on this, but I don't have the time. But pillar 1 of our case on risk of dissipation here is a man who has given a false explanation to his joint venture party in order to explain an event or a proposed event which strikes, as I say, at the heart of the joint venture. He then provides false explanations for it. We say on 2 occasions, witness statement 2 and witness statement 4. A man who is willing to extract money from a joint venture under false pretenses is classically a man who poses to this court a risk of dissipation, in my respectful submission. But it doesn't stop there. I go on to my second pillar. I'm going to take this relatively shortly because your lordships have heard a lot about this in different contexts. The case that is pleaded in Scotland, which your lordships have had cause to glance at, I don't have time to take your lordships through the full pleading. The conspiracy is at paragraph 35, and there's of course a long run-up in the pleading up to paragraph 35, and it continues into 36 and 37. Involves allegations, we say, of the most serious nature. Because what they involve, amongst others, there are a whole host of allegations made, but for present purposes, they involve the suggestion and the proposition and the case that Mr. Gollitz, in conjunction with a number of other actors, we know their names, we know who they are, conspired to bring proceedings in Luxembourg, which were founded on an absolute fallacy, the Golden Prison, the economic violence, the fake trial. Mm-hmm. I haven't got time to take your lordships through the allegations made in the Luxembourg proceedings, But I would invite your lordships, I know I don't want to give your lordships homework, it's not my place to do so, of course, to cast an eye over those Luxembourg proceedings. They're there in French, they're there in English. They were served on my clients on the 2nd of March 2021.
And the reference is,
The reference is, my lord is going to get that reference.
if you're going to be giving us homework, that's
No, no,
completely
no, your lordship's question is,
completely fine, but you need to give us
no, no,
the
no, your
reference
lordship's,
to
It's
some.
not completely fine.
you know, when I say completely fine, the question is entirely
Anyway.
legitimate, was my,
Well, the reason why you've got limited time, we all know.
Yeah.
So don't keep saying it. because it
281,
makes
my
me
lords,
think you're
281 of
trying to set us up for
the
not
supplemental
giving enough
one.
time.
Sorry, my lord, I overspoke.
I said, it makes me think you're trying to set us up for not having given you enough time.
My lord,
Mr.
I
Grant.
promise you I'm not trying to do that. I genuinely am not.
Right.
Page 281 of the supplemental bundle tab, badge 43. My lords, it contains the most remarkable set of allegations. We respectfully suggest that the Luxembourg proceedings and the BVI proceedings, and this is the pleaded case in Scotland, are the product of a conspiracy, and they involve allegations of an abusive nature against my clients. And we now say, respectfully, that the documents, the new documents that have been brought in, or DBNASA, I should say, and I specifically dwelt upon certain paragraphs, I'm not going to go back through certain passages within those documents. And your lordship will have heard, or may remember, that I said yesterday, there you are, it's not often that one sees the conspiracy laid out in black and white, and I adhere to those submissions. And I suggest to your lordships that the second pillar, Mr. Gollett's involvement, and absolute deep involvement, not peripheral, to those proceedings goes a very long way to establishing a risk of dissipation. A man who is prepared to involve himself in abusive proceedings to further corporate ends amply fulfills the criteria of a risk of dissipation. And your lordships will have seen how it's put in the various new documents. So that's all I wanted to say about that. I really made that point yesterday at some length.
One can see it really, a flavour of it, I suppose, from page 299 in the English, top paragraph. It must be noted that the facts described above sufficiently demonstrate the violence exercised in the form of psychological pressures, etc., etc.
Your lordship has it. Your lordship has it. So that's the second pillar. Part of which, of course, is the attempt by Mr. Gollett to hide from this and to deny it and to hide in the shadows, we would respectfully say, which has now been revealed. The curtain has been pulled back via some of those documents. In particular, my lords might find document 34 and document 64 relevant. I'm going to give you the page number for those. 227 of the Ladder Marshall bundle and 64, 65. I'll give it to you in a second. My lord, the third pillar of risk of dissipation, we say, is all the various untruths that we suggest have been revealed by the new documents contained in Mr. Gollett's witness statement of the 16th of November. And I went through those yesterday. I don't go through them again today. Your lordships will remember my presentation on that yesterday. And I went through paragraph by paragraph, showing your lordships what had been said to the court below and showing the truth. And we say that a man who is prepared in seeking to discharge a freezing order to put false evidence, and not just occasional false evidence or extraneous mistake, but at the centre of his evidential platform, again, very substantially establishes a risk of dissipation. And the fourth pillar, my lords, is what I describe broadly speaking as the hidden interest in CSM. Your lordships have ample evidence of the hidden interest in CSM. We have all the documents about him being a founder and the initialisms and so on. I don't go back over those. Your lordship may recall the introducer agreement where Mr. Gollitz is going to get 6% on everything that comes into CSM. He claims that it was never actuated, that agreement. Well, we don't know. We don't know. We only have what he says about that. Then we have a document I don't think your lordships have yet been shown by me, but I very briefly show it to you. I'm so sorry. We're back in the Ladder Marshall bundle. I'm so sorry. And we go to a document which is at page 347. It's document 60 as it happens, but 347 will be more of assistance to your lordships. And it is a loan agreement between Mr. Gollitz and Regal Consultancy International Limited, dating to May 2023. Regal is the same entity that he entered into the introducer agreement 2 years earlier. It is a company under the control of Mr. Cormack and Mr. Ford. It is one of the companies that feeds business to CSM. We know that from the earlier document. And here, quite remarkably, you might think, Regal is giving Mr. Gollitz, not VDHAG, Mr. Gollitz personally, a loan of €300,000. Unsecured. What on earth is going on there, we ask? Mr. Gollitz has not vouchsafed, as I recall, any answer at all in his witness statement. He's silent about this document. Now, we respectfully suggest this document demonstrates very clearly that Mr. Gollitz is deeply involved in CSM. He is indeed the Michael of M in the CSM name. He's hidden his involvement, I quite accept that, but he's obviously got very good reason to hide his involvement, given that CSM has a business relationship with his employer. Why is he receiving an unsecured loan in this way a year ago, 14 months ago? No explanation. We respectfully suggest that the totality of the evidence disclosed in the new documents, and indeed the case that was put before Mr. Tinkler, but of course with one arm tied behind our back, demonstrates that Mr. Gollitz has a hidden interest in CSM. He is not being candid with the court about that interest. And that is, as my Lord the Chancellor intimated earlier today, not of course in the context of this case, but generally, I'm not suggesting any conclusion be arrived at, is a classic indicium of a person who presents a risk of dissipation. My Lords, those are the four pillars of the case against Mr. Gollitz.
Do you accept that the second, third and fourth substantially depend on the new evidence, although the first one was there before?
The third and fourth are very substantially benefited by the new evidence. The second exists independently of it, although it's been very substantially supported by those two documents, amongst others that I mentioned. And let me give you the numbers again. Document 34, page 295. Document 63 to 65, that's all the Schmidbauer stuff, pages 364 to 377, I don't go back over that. The third and fourth, my lords, I accept are substantially benefited by the new evidence. Although there was an existing case about CSM placed before, based on the evidence available at the time, placed before Mr. Tinkler. But Mr. Tinkler, you may recall at paragraph 60 of his judgment said, well, it's said that CSM stands for Collins, Stewart and Michael, but that's based solely on
That's from Mr. Duffy.
what Duffy had to say at a meeting 2 years ago, and everyone says Mr. Duffy is a loose cannon, putting it broadly and neutrally, and therefore I can't really rely on him. But now we have an email sent in November 2020 from Mr. Smith saying CSM is an initialism, Michael has to be involved. Of course, it's a matter for your lordships whether your lordships exclude that from your lordships' consideration. An email which I don't think my lords had any explanation for, whether in submissions or in evidence. My lord, VDHAG I turn to. Now, VDHAG stands, obviously needs to be considered separately, but nonetheless, as I said to your lordships before the short adjournment, it is not presented separately from Mr. Gollitz, it is not said, as it might have been, well, Mr. Gollitz doesn't really have any power over AG, we're putting in our own evidence about ourselves, Mr. Gollitz is just a little island somewhere in the corner. The only evidence you have from AG comes from Gollitz, and there's no distinction drawn between the two of them in terms of the risk of dissipation. As far as we're aware, Mr. Gollitz has power of disposition over the assets of VDH AG. No one suggests otherwise, and therefore everything I've said about Mr. Gollitz is equally applicable to VDH AG. But it goes much further than that, because VDH AG, we know, is owned as to 60%, and this is common ground, by Mr. von Bottker, who is the 60% owner of AG, and was, until it went into insolvency, the 100% owner of VDHI. So until that moment, Mr. von Bottker had corporate control over both companies. And I wish to deal now with VDHI because that tells us something about that control, or that previous control, which feeds into an assessment of VDH AG. So just turning to VDHI, prior, I accept, to its insolvency, there was a mass of evidence about VDHI's corporate practices, which gave rise to significant concern. I'm going to list them briefly. There was the case on the merits as a co-conspirator. I've dealt with that. I won't go that over again. There was the long sheet of charges against it from CSSF about its corporate behaviours. The document itself is supplemental bundle tab 13, page 159. Your lordship's seen it already. There was, within Mr. Yahya Tahir's affidavit 3, a long set of points made against VDHI and its corporate propriety. They start at paragraph 140 of his third affidavit, which is at supplemental bundle 1172243, a wide survey by Mr. Yahya Tahir concerning VDHI's corporate personality and its tendencies and its propensities. There was also a substantial amount of evidence placed in Mr. Yahya Tahir's first affidavit, the one that was placed before Mr. Justice Lavender, from paragraph 25 onwards about that same question. Supplemental bundle tab 93, page 1836. And there was also yet further evidence from Mr. Nasser Tahir in his affidavit 1 at paras 64 to 77, that's supplemental bundle 116, page 2185, about that and the intimate interrelationship between VDH AG and VDHI. One of the points raised below was, oh, they're separate freestanding companies, they make their own decisions, they're not connected in any way, notwithstanding the fact that Mr. von Bottker at that stage, by common ground, was the owner as to 60% of the one and 100% as to the other. The final point about VDHI was the circumstances in which it was sold out of the VDH group in some point in mid-2022 to a special purpose vehicle called Cambria, owned 100% by Mr. von Bottker. And so essentially it left the VDH group in July 2022. And I think that was only discovered after the event during the BVI proceedings, because there were no proceedings in Scotland at that stage. Now, of course, it is, and what I say about that is all those points about VDHI that were applicable back in December 2023 were cast doubt on and shed light on the propensities of the UBO of VDH AG, which adds to the points I made about Mr. Gollitz's role top up, Mr. von Bottker top down, bottom up. My lords, VDHI, I want to spend just 2 more minutes about VDHI, because of course it has now entered into a form of insolvency, and it might be said that well, the analysis needs to change, given that it is no longer in the hands of directors and no longer in the hands of the shareholder, but has gone into the hands of Mr. Rukavina. Now, our concerns nonetheless remain very strong, and they remain strong for essentially 2 reasons. One is that it is not at all clear that Mr. Rukavina has actually managed to obtain corporate control or control over the assets of VDHI. He appears to be working on some sort of shoestring in terms of his activity. He's not participating in the BVI proceedings. he is not communicating particularly substantively in any of the proceedings. Peters and Peters have come off the record. Carey Olson and the BVI remain technically on the record but are in a state of stasis. So it's not at all clear that we can now take comfort from the fact that Mr. Rukavina has brought in the assets and they're now in a safe harbour. The second point, which is particular to Mr. Rukavina, is that your lordships will be aware that we wrote to him on the 25th of June offering a proposal about how to dispose of this appeal. We have had not one response of any shape or form from Mr. Rukavina. The fact that now a month has gone by and a court-appointed insolvency practitioner in Luxembourg has not communicated in one shape or form with my clients gives rise to very serious concern about what he's doing, what the terms of appointment are. I'm not going to start making aspersions against Mr. Rukavina as a professional person in this court. It'd be wrong for me to do so. But nonetheless, precisely what his role is, given that he has lain doggo for the last month, is a source of substantial concern to my clients. And my lords, we've set out in our Adam Marshall skeleton argument at paragraphs 87 and 67, 2 cases where injunctions were granted of a freezing nature in insolvency situations. It's not as if once an insolvency practitioner is appointed, all concerns somehow disappear. I haven't got time, so I'm not going to use that phrase. Sorry, I'm not going to show your lordships those cases, but they are cited in, and I don't think I need to. The jurisdiction to grant the freezing order remains, and in one sense it might be to the assistance of Mr. Rukavina were the freezing order to be granted, because of course it would apply to anyone and be enforceable against anyone who interfered with the order. And therefore, if Mr. Rukavina has found difficulty in actually bringing in the assets, a freezing order might assist him in that task. My lords, that's all I wanted to say about risk of dissipation. I wish to now move on straight to expediency. My lords, your lordships will be aware that the jurisdiction under which we sought the order is contained in section 25 of the 1982 Act, which is in your lordship's bundle, authorities bundle. I don't go to it, at tab 5, page 46. And your lordship will of course be aware of how the statutory words are cast and the way that the courts have developed a two-stage test. Stage 1, were this case proceeding substantively in England, would we grant the order? If yes, we move on to stage 2. The fact that the proceedings are in fact being brought in a foreign jurisdiction, does that make it inexpedient by reason of that fact alone to grant an order which we would otherwise be persuaded to make were the proceedings purely English? Now, the submission that was made at first instance by Mr. McGrath, speaking with some authority, it's fair to say, and far more than I could ever muster, was that section 25 had been introduced at a stage in the history of the English law when the English lawyers were proceeding on a joint misconception as to the common law right or power to grant injunctions. And your lordships will be, of course, familiar with the fact that the Siskina was the dominant authority from the time it was decided in 1979, and it was the dominant authority for the proposition that no injunctive relief could be granted in England absent an underlying cause of action, hence the need for statutory intervention to create a right where it did not exist at common law. And the submission that was made with eloquence, if I may say so, by Mr. McGrath below, was that that misconception had been exploded in the Privy Council decision in Convoy Collateral, and that had made clear that in fact the Siskina had been wrongly decided. Now, my lord, with that preface, I wish to go straight to my lord's judgment below. Core bundle, tab 10, page 152, where your lordships will find, this is within the body of the judgment, your lordships will find the phrase not inexpedient. I think the word later above is a transcriber's word, because I think the judge rose and then came back into court to continue the oral judgment he delivered in, on the Friday.
152, isn't it? Yeah.
Thank you, my lord. 152. And his lordship's consideration of this aspect of my case, my client's case, was short indeed. Not to say that doesn't mean it wasn't sweet, but we say it wasn't sweet. We see at para 64, he turns to consider section 25. He refers to Domenico and Uzan, and your lordships have been shown Uzan already. The bulk of the judgment really starts at the main part of the judgment on this aspect starts at para 67. In my judgment, it could not be said that any of these defendants has any significant or, in my judgment, meaningful current connection to the UK. If the defendants are right that this is the test, that was the test advanced below and is advanced before your lordships, then none of these defendants pass that test. The injunction will be discharged and not continued on that basis. And then he goes to what was said by Mr. McGrath. The claimant says the test is, broadly speaking, comity, justice and expediency. The courts in the I want to just unpack the sentences here in a little detail, because we would respectfully suggest the court below goes wrong. The courts in the BVI are seized of the principal litigation in this matter. That's just wrong. The principal litigation in this matter is the case in Scotland. My client's application was not an application in support of relief, in support of proceedings in the BVI. My client's not even a party to the proceedings in the BVI. My client's MGWL. The only parties in the BVI are MBFX, which is a subsidiary, and Mr. Tahir personally, the UBO. So that's the first error of paragraph 68 we respectfully suggest. Then we get to the next sentence. These three defendants are currently party to that litigation. That was, pausing there, technically true in the sense that I've identified. They were challenging jurisdiction at that time and had taken no further steps in the proceedings because of that challenge. And then this, and the courts in that jurisdiction have the ability to grant the order which Lavender J granted. Wrong and inexplicable. MGW was not a party to proceedings in the BVI. The claim in conspiracy that it brought was not a claim it had brought in the BVI, it was a claim it had brought in Scotland, and only Scotland. So that's wrong as well. Next sentence. Sentence 4. Although this claim is ostensibly based off a Scottish case, pausing there, wrong. It's not ostensibly based off a Scottish case, it is 100%, beginning, middle and end, based off a Scottish case. It is based in substance on the issues of the BVI case. Wrong. We say in Scotland, the proceedings of the BVI are part of the perpetration of unlawful means against my client. It is a matter for the Scottish courts as to how that litigation is determined. Well, that's, I suppose, correct. It does not follow, however, that if there is a live case in Scotland, then the English courts must grant orders such as this. Well, that's true. The mere fact of foreign proceedings doesn't ipso facto require the English courts to grant orders. That's just section 25, the discretion set out therein. Final sentence. In my judgment, it would be inexpedient to create parallel and duplicative litigation in these courts. And I regret to have to suggest to your lordships that last sentence appears to suggest that his lordship below had a profound misunderstanding of what section 25 is all about. It does not create duplicative litigation. There are no causes of action being advanced before the English courts. The English court is merely being asked to be a handmaiden to the main court in Scotland. So we would respectfully suggest that paragraph 68 contains multiple errors of analysis which vitiate the court's analysis of the question and answer to that question. Para 69, there was some reference in this case to the role of the English courts as international policemen. The claimant pointed me to the requirement in the English courts to have that role, particularly in the case of international fraud. I'm going to come back to that. Merely because a matter is international and involves dishonesty, it does not, in my view, necessarily become a matter of international fraud. Well, technically that's true. Nothing necessarily follows from the other. But then we see the way the judge fortifies that provisional conclusion or conclusion at paragraph 70, where he refers to two cases well known to this court and well known to the English law, Haiti and Fundo Sobrano. Both involved, as the judge rightly says, large-scale misappropriation of assets from governments, stripping of assets from the Angolan government and the Haitian government. It was, in effect, large-scale financial fraud. No doubt in both cases that existed. This case is not like that. There is no allegation of movement of assets, except, of course, the allegation of movement by the claimant of the 10th defendant's assets. There is a dispute as to whether, in essence, the BVI compromise was a sham, and your lordships can perhaps read on to the end. Last sentence, this does not, in my view, reach the threshold of international fraud that would require this court to police matters which are clearly within the jurisdiction and powers of another court. It would appear, my lords, that his lordship below took the view that unless the claimants could point to some mass misappropriation on a large scale or mass depredation by fraudulent individuals of state assets, then the court had no power to intervene. That is just wrong. There is no such test established by Section 25, either in the past or now. The judge, in my respectful submission, set up an entirely false threshold, unknown to the English law, and having set it up, held that my clients had not surmounted it. If he had set up the proper threshold, then, in my respectful submission, he would have inescapably come to the conclusion that we had surmounted it. My lords, the last paragraph is paragraph 71. Even if the claimant is right about the correct test to be applied, it's not entirely clear that the judge actually understood what the correct test to be applied was. I would, for the above reasons, well, all the reasons which are wrong, I would have declined to grant the injunction. But the above reasons include, and there's this rather Delphic statement, the above reasons regarding the BVI litigation, and as this is not a case of international fraud requiring policing by the English courts. Well, what he appeared to mean by that is, it's not a Haitian case, it's not an Angola case, therefore you're out of court. Wrong, 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 in my respectful submission. My lords, that's all I wanted to say about the judgment. It's as simple as that, it is as short as that. The true analysis starts with two classic judgments of this court, Credit Suisse and Motorola. Your lordships have yet to look, at least in this case, at Credit Suisse, and may we briefly turn to that. It's tab 17, bundle 1 of your lordships' newly, hopefully helpful bundles. It's a very well-known decision of a very strong court, if I may respectfully suggest. I don't go to the facts. I simply wish to show your lordships certain hallowed paragraphs of Lord Justice Millett and the Lord Chief Justice, as he then was, judgment. My lords, we can pick up the bundle at page 228 of the external pagination, where Lord Justice Millett, as he then was, refers to the Siskina at the top of the page, which of course at the time was binding on everyone, other than the Supreme Court if it chose to disapply it. He refers to the origin and genesis of Section 25 at the top of the page. He refers to the fact that it was enacted in accordance with treaty obligations under the EU and to bring into effect Article 24 of the Lugano Convention, little d, halfway down the page. He then quotes the section further down the page, and then in a very well-known passage, his lordship, at the end of 228, starting with the words, the wording of section 25.2 is inelegant, sets out his understanding, his lordship's understanding, I should say, of the way the section works, and sets out an expansive understanding of the nature of the jurisdiction over the page to little b, and I'd invite the court to read to the end of the first paragraph at page 826. So Lord Justice Minnett's conception of the jurisdiction, as I say, was an expansive one. It continues at page 827, his analysis of the law. And may I just briefly invite the court to look at, this is page 230 external, the paragraph at E through to F. And may I invite the court just to read that as well, please.
So which page again?
Page 230 of the external, 827 internal.
Following page and the paragraph.
I recognise there's an ancillary
That's it. Thank you
jurisdiction.
very much, my lord. That's it. Just that paragraph. And my lords, I show this to my lord because, as my lord, Lord Justice Mayles yesterday was interested in what Mr. Brown had to say about the way the Scottish court exercises or does not exercise any jurisdiction it may have. What is clear, we respectfully suggest, from this passage of Lord Justice Minnett's judgment, is that the fact that the local substantive, so the substantive court, does not have power to grant a worldwide freezing order, or we would say, putting aside nice questions of jurisdiction, which have always bedeviled legal learning over the years, Lord Justice Pickford's famous judgment in the guarantee case in 1915. Let's not too worried about the precise nature of jurisdiction. What Mr. Brown says in Scotland is that, and I gave your lordships the references yesterday in his opinion, that the Scottish courts do not exercise an extraterritorial jurisdiction as a matter of practice. Whatever the reason for that, they do not exercise it. And the clear distinction to be drawn, my lords, just pausing there at this passage, is between the local court, the substantive court, which does not exercise, whether because there's a statutory prohibition to do so or because it just doesn't have a conception of an extraterritorial jurisdiction for whatever reason. There's a clear distinction between that scenario and the scenario where the substantive court has an untrammeled jurisdiction but has chosen on the facts of the given case not to exercise it. And it is quite clear that in that second category of case, where the claimant goes to the substantive court and says, can I have my worldwide freezing order? And the substantive court says, for various reasons, no. It would be quite wrong for that claimant then to buzz off to the ancillary court and have a second bite of the cherry and knock again and see if he can do better there. That I accept would be impermissible, but that is not this case, if I can interject with the facts of this case. And
Two points arise
my
from
lord,
it.
yes.
First, we don't need to look at it, but Mr. Brown's opinion is a little hard to pin down. It looks as if the Scottish courts don't really like doing it. It's slightly odd. I mean, they clearly have the power. They just don't tend to do it. So that is a slightly odd halfway house, isn't it, between your two examples? They either have the power or they don't. Here they have the power, they just don't really like exercising it.
I suppose you might say it's a distinction between having the power and not exercising it on the facts of the particular case, on the one hand, and having the power, as it were, generally, but never actually exercising it in practice,
Well, I think,
irrespective
yes,
of the facts of the particular case.
I think I suggest we're in the second, my lord's second
That's what
category.
I was going to say.
I don't want to engage in a
I understand
nice
the point, but
exegesis of what Mr. Brown says. And
like my lord, I was slightly concerned about.
Forgive me for overspeaking. Forgive me for that.
No. Yeah,
Look,
okay.
we could spend some time divining Mr. Brown's opinion. I don't think that would be a necessarily.
I'm anxious not to do that.
No, I'm sure your lordship wasn't. But it speaks for itself. I've got nothing more to say about it than what it says itself. It's written by a very experienced junior advocate in Edinburgh, and I would respectfully suggest what it indicates is not that this court would have said, well, I'm not going to grant the injunction against Mr. Gollitz or Mr. whoever because I don't think you've got a risk of dissipation or what have you. In fact, what we do know is the judge was asked to grant an injunction of the domestic kind and was willing to grant it against all the respondents so far as they had assets in Scotland.
Yeah. And
what Mr. Brown very much does say in his opinion is that the Scottish courts would not be in any way offended, undermined, agitated by the step that we were proposing to take. In fact, he suggests that the court in Scotland would be assisted by it and and this breathes into the next case I'm going to come to in 2 minutes. So let me not preempt that submission. So, Lord,
Well, what Mr. Brown also says, and I take the point that it's not necessarily very helpful to try and pass his opinion too much, but
No.
it is all we've got as to the attitude of the Scottish courts.
Yes.
He says that they prefer to leave extraterritorial injunctions to the jurisdiction where either the defendant or their assets are located.
Well, whether he goes quite that far, again, I don't want to engage in a parsing exercise with your lordship. My interpretation is that the courts would encourage a sister court, if I can use that phrase, as in this court, which is of course a court under a single sovereign and which is part of a single sovereign state, would be assisted if the English courts, which are much more willing, of course, to exercise extraterritorial jurisdiction, would step in and assist the Scottish court. And there's been no suggestion from the Lord Sanderson ever since these injunctions were granted way back in October, and there have been multiple hearings before Lord Sanderson ever since, and of course he's very well aware of these proceedings. As my Lord said yesterday, he granted an order allowing documents to be placed before the English court, and one might have expected, if he took the view that this was a gross breach of Scottish legal etiquette or somehow infringed the jurisdiction of the Scottish court, one might have expected Lord Sanderson to have made his views pretty expressly clear at his dissatisfaction with the steps that were taken, and of course openly taken in England by my clients, taken 2 days after the ex parte application had been moved before him in Edinburgh on the 17th or 18th of October.
Were these defendants party to that application?
Well, they are part, and I think it's common ground. These defendants,
No, they're party to the litigation, but
no, they were in this, and this is in fact the letter that the solicitor's letter put in by my learned friends in the Ladder Marshall application, which my learned friend read some parts of it to you, make absolutely clear that the order that was issued as under the summons, the quasi-phrasing order, is an order against all the defendants, but as a matter of practice, it has no practical impact on my learned friends' clients because they don't have assets in Scotland.
You know that, I know that.
Yeah.
But I'm asking about whether they were party to or present at or given notice of the application to Lord Sanderson to use the documents disclosed by the Scottish or seized from the Scottish defendants in the English proceedings.
I don't know the answer to that. But they are not their documents in the sense that they were documents seized from addresses in the
So no,
ownership.
but if they'd had notice of it, they might have had the opportunity to come and say, this is not the kind of thing the Scottish court should be doing.
No, well, I
If they
don't
weren't
know
given
his
notice
answer.
of it, they didn't have that opportunity, so we just don't know.
I don't know. Maybe there's an answer which is going to come from behind, but at the moment I'm going to proceed on that basis until I'm told otherwise. My lords, but the important point is that Lord Sanderson had this case before him on 6 times in the last 8 months, where different iterations of parties have attended, and my learned friends' clients have.
You can sympathise with them.
Yes. Well, that's a separate point. My lords, so that's, let me move on. 827, I've shown you that. The next passage I wanted to show your lordships is 829, external pagination 232. Where, again, the expansive conception of the jurisdiction is outlined by his lordship. And my lord, can I then show your lordships briefly 2 passages from Lord Bingham's judgment, just to complete the picture. 831C, page 234, external pagination. That paragraph starting at subsection 2, and 8235, so external 235, paragraphs H at the bottom of the page, over to 232 833. Forgive me, I'll give you a completely false reference. The bottom of the page, 234, internal 831, over to B. My lords, that's Credit Suisse, and I show it to you because, of course, it's a case of great significance in this area. Can I just very briefly show you a decision of Mrs. Justice Gloucester, as I think she then was, which is in, let me just make sure I get the right bundle for your lordships. It's tab 31, which is bundle authorities, tab 31. Bundle 2. This is a decision of Mrs. Justice Gloucester, which has been, I think, been cited quite significantly since it was decided. Very briefly, my lords, on the question that we were debating about 5 minutes ago, at page 599 of the external pagination, we see in her ladyship's recitation of the general principles, which are, I should say, all, as one would expect, of enormous assistance, but I'm not going to take your lordship through the totality of paragraph 36. But we see column 1, bottom of page 599, little Roman 7, a restatement of the point that was being debated with my lords 5 minutes ago. Roman 7, 599, bottom of column 1. I say no more about that. My lord, the other judgment of enormous significance in this area is, of course, Motorola and Uzan. That, I believe, is volume 1, tab 21. Your lordships have been shown some passages of that. The last, I don't want to go over those. The last passage which I wanted to show you is at paragraph 115, page 358 external.
Was actually cited by Mrs. Justice Gloucester in subparagraph 8.
Thank you, my
The
lord.
whole of paragraph 115. So
In which
we don't
case,
really need to-
in which case I should have left it there. That's your lordships.
I think it's all quoted. The 5 considerations.
The 5 considerations, and this was a quote. This passage was quoted by Mr. McGrath below in his skeleton and urged upon the court. And the point that he advanced below, which I very much adhere to, is that in the 5 considerations which are expounded by Lord Justice Potter, if one actually analyses those against the case here, they all point, we say, in favour of the grant of the injunction. And the point that Mr. McGrath made, which I very much repeat with respect, is that none of those 5 considerations requires there to be residence within the jurisdiction by any of the defendants or the presence of substantial assets of any of the defendants. And that, of course, is a matter which I need to address, and which I will address in short order, because, of course, as your lordship knows, the view of his lordship below and the submission urged by my learned friends below and before this court is that the fact that none of the respondents, VDHAG, Gollitz and VDHI, treating those as the 3 respondents, are resident within this jurisdiction or have a substantial amount of assets within this jurisdiction should, in and of itself, answer the question as to whether the court should exercise its jurisdiction over them extraterritorially. Now, the evidence on that at first instance was, first of all, Mr. Brown's opinion, which your lordships have read and considered, and I don't propose to go over it with a fine-tooth comb with your lordships. It speaks for itself and stands for itself. There was also evidence from a Luxembourg lawyer and a German lawyer by way of letters to say that those jurisdictions did not have the concept of the freezing order, but did not object to such injunctions being made against its residents or assets. There was no countervailing evidence, so I understand, I may have got this wrong, but I don't think there was, from the respondents by way of their own German lawyers or Luxembourg lawyers, or indeed their own Scottish lawyers responding to Mr. Brown's 20th of October opinion. And it is against that background that in our skeleton argument which is before your lordships in the core bundle, and your lordships may have that bundle open at page 153 at the moment. But if your lordships were to turn to my skeleton, I didn't spend very little time on my skeleton because your lordships have it and it doesn't need real elaboration. My skeleton argues at tab 3, my lords, and in particular, your lordships will find the relevant paragraph submissions at page 49. Or they start at 48 of the external pagination of the core bundle, where we set out our submissions. And we set out a number of contextual points at paragraph 1, 2, 3, which we say should inform the court's jurisdiction and should have informed the court's jurisdiction below. I'm not going to repeat those now, but paragraph 1, 2, 3, we set out a number of contextual points. And one of the important contextual points, before I get to the law as it now stands, is the fact that this is a main proceeding, not taking place in America or Kamchatka or Algeria, but in Scotland, i.e. in a court which is part of one sovereign state, being the United Kingdom, with one sovereign being King Charles III, and where the courts, of course, as we know, have one single final court of appeal, whether it's a case heard in Edinburgh or a case heard in London. And we say it is a material factor to take into account, which his lordship below did not take into account, that the assistance being sought from this court is to a court within the same overall sovereign state of the United Kingdom. Now, the test adumbrated by my learned friends below and above and here is identified in his lordship's judgment back to paragraph 67, which is page 153 of the core bundle, was lack of significant or meaningful connection to the UK. And his lordship agreed with that. Now, we respectfully suggest that my learned friends have got the law wrong, with the greatest respect, and that the test that operates within this, under section 25 now, is not a test so constrained by those threshold impediments. The starting point is the fact that section 25 was legislated in order to give effect to Article 24 of the Lugano Convention. We've seen that in Lord Justice Millett's judgment in Kuogi and Credit Suisse. I don't go back to that. And we know that in interpreting Article 24 of the Lugano Convention, the ECJ had set out a test requiring, within the subsidiary court, the existence of a, quotes, real connecting link between the defendant sought to be injuncted, or against whom interim relief was sought, and the courts of the jurisdiction where that ancillary jurisdiction was sought to be exercised. And that is the case of Van Uden, which I don't go to, but it's tab 18 of your lordship's authorities bundle, and the relevant statement of the law is at paragraphs 37 through to 40. Now, for obvious reasons, given that Van Uden was a decision of the European Court of Justice, and because section 25 was enacted to bring into effect, through treaty obligations, Article 24 of the Lugano Convention, the learning within the English courts has been suffused thereafter by the perceived need for a real connecting link. And one sees that in a whole host of judgments which are collected in your lordship's authorities bundle. There's the Impressa case at tab 24. There's a case well known to this court in Belletti in tab 27, Motorola, tab 21, and the case which my learned friends place reliance on, and which the judge below cited, that the decision of Mr. Justice Popwell in the Dominico case, Authorities Bundle, tab 33. And in each of those decisions, the real connecting link test was referred to, and one understands why with respect, given what had fallen from the European Court of Justice. And my lords, we can see the prevalence of the Van Uden test being analysed with some care and assistance to this court in a more recent decision of Mr. Justice Jacobs in ArcelorMittal, which is tab 43, and I'm going to be told by volume 3 of your lordship's bundle, Authorities Bundle, tab 43, decision of Mr. Justice Jacobs in ArcelorMittal. And we can go straight to paragraph 73, please, which is page 994 of the external pagination, tab 43, that is. And paragraph 73 starts after Mr. Justice Popwell's influential analysis in Dominico, which I think was, ConocoPhillips, which I think is, broadly speaking, I think he recited a similar analysis. Yeah. At paragraph 73, there is, and what, I'm going to read this out for a second, if you don't mind. There was no dispute that this is a good summary of the relevant principles. There are, however, a number of matters which I consider to be important in that context. First, as is clear from paragraph 44 of the judgment, Mr. Justice Popwell was not considering a case of international fraud. Secondly, it is clear from cases such as Haiti and Duvalier that in cases of international fraud, the English court may be more willing to intervene. Pausing there, of course, that's something the judge below glanced at, but then set it up as a kind of test where you had to prove sort of mass depredations on a sovereign state, as we've seen. And then a reference to the Venezuela case, Mr. Justice Walker indicates that in case of international fraud, the court would not look for such strong connecting factors with England as it would in other cases, see in particular various paragraphs. Thirdly, the present case is not a case where Section 25 is directly applicable, because it was a case under Section 44 of the Arbitration Act, and therefore the decision in Van Uden does not provide a constraint of requiring a real connecting link. And what Mr. Pito case, QC, as it then was for the claimants, suggested was that the ultimate question was that mandated by Section 37 of the Senior Courts Act. That's the bottom of paragraph 73. And we can then see, for what it's worth, at para 75 over the page, a question of what the phrase international fraud might mean. And there's an interesting analysis, if I may say so respectfully, by Mr. Justice Jacobs about that at paragraph 75. But what is clear from that judgment is that A, there's always been a wider conception of the jurisdiction in cases of international fraud, and we say, so far as we need to, we don't think we need to anymore now, that this is patently a case of international fraud. Fraud doesn't mean deceit, just as Mr. Justice Jacobs said in 75. And it certainly doesn't mean depredations on a vast scale from a sovereign state. My lords, the law has changed in two important ways in the last few years. The first way it has changed is that as a result of the EU Withdrawal Act 2018 and the retained EU Law Act 2023, the primacy of EU law has been definitively abolished. And we can see that, my lord, if we go to Authorities Bundle 1, tab 9, page 72. And we go to page 74, section 4, abolition of general principles of EU law. This is the 23 Act. There is to be inserted within the 2018 Act a new subsection A4. This is a third of the way down the page at 74. no general principle of EU law is part of domestic law after the end of 2023. Now, of course, it could be said, well, the judgment was handed down on the 15th of December 2023, and therefore there were 16 more days. Well, we're now in 2024, and the notion that the happenstance of when this case was heard should finally dictate the outcome of this appeal is not one I don't think my learned friends, I withdraw the word even, my learned friends suggest in this case. So EU law no longer has primacy within domestic law, and therefore the principles set out in Van Uden, which were no doubt in years gone by of binding effect, are no longer binding. So that's the first very important thing that has happened, and indeed section 25 has now changed, and I'm not going to go to it, but you'll see the two iterations of it at Authorities Bundle tab 5.
You said it was legislated in order to give effect to the Lugano Convention, which is not part of EU law.
Well, the Van Uden decision is a decision of the European Court of Justice,
Yes.
and Van Uden therefore is a part of EU law, and section 4 now says that is no longer, that the English courts should no longer have regard to EU law when it comes to interpreting English statutes, but a lot more than just interpreting English statutes. Section 25 now stands, we say, unaffected by the Van Uden rule, but equally importantly is another seismic event in English common law.
Yeah.
Forgive me for, there is your lordships may be assisted by looking at the totality of sections 3 through to 6 of the 2023 Act. I won't show them to you now, but they are from pages 72 through to 78. Paragraph 6, section 6, for instance, is headed the role of the courts, where further insertions are made into the 2018 Act. But I leave that to your lordships, if I may. The second seismic event in the English common law is, of course, the decision in Convoy Collateral of 2 or so years ago. And of course, in that case, a 7-person Privy Council, I think it was a 7-person Privy Council, decided, as I've said, that the rule in the Siskina was wrongly stated and is no part of the common law. And that, of course, means that the rule or the conception that in order to grant a freezing order or any kind of injunctive relief, there has to be an extant or a recently proposed or soon to be made substantive claim within England, no longer applies. And I'm not going to start expounding to your lordships what precisely the perimeters of Convoy Collateral. That would require a long disquisition, and your lordships don't need it from me anyway, given that your lordships would have no doubt considered that case closely in the recent past. But of course that was a decision of the Privy Council, and there was at one point perhaps a question mark as to the extent to which that represented the English law. That question mark has now been answered by the recent decision of the Supreme Court in the Wolverhampton Borough Council case, which I think your lordship should look at. Tab 61 of your lordship's bundle, which is bundle 5, page 1913 of the external pagination. And I just wanted to show your lordships 3 paragraphs of that judgment. First of all, paragraphs 16 onwards. Page 1923, under the heading "The Jurisdiction to Grant Injunctions," we have a reference to the well-known case in Fourier LaRue, the reference to the decision I was mentioning earlier, Lord Justice. Sorry, paragraph 16 in the Guarantee Trust of New York case, which deals with the nice question of jurisdiction. And then, more importantly, paragraph 17, where statements are made about the origin of the right of the power to grant injunctions. And of course, it was an equitable jurisdiction which has been rendered statuified by section 37. And the breadth of that power is referred to over the page at the end of 17. We then go to paragraph 21. The width and flexibility of the equitable jurisdiction is not to be cut down by categorizations based on previous practice. Paragraph 21, page 1924. The width and flexibility of equity not to be undermined by categorization over the page at page 1925. And then finally, para 43, where the court comes to the Siskina and convoy collateral, para 43, page 1930, headed injunctions in the absence of a cause of action. And I think it's rightly understood that this case finally decided, if there was any doubt about it, that the law as expounded in the convoy collateral was part of the English law, not the BVI law only. Now, what does that mean for the purposes of your lordships? What it means is, we say that it is understandable that section 25 has in the past been interpreted in a narrow way, albeit Lord Justice Millett flagged the future for two reasons. One, because the courts, and everyone of course, not a criticism of anyone, has been labouring under the conception that the right to grant injunctive relief is limited by the Siskina principle. Section 25 was seen as a derogation, a statutory derogation from the Siskina principle, but necessarily was given a relatively narrow jurisdictional breadth. And that narrow jurisdictional breadth was compounded by the conception of the ECJ in Van Uden. Those two shackles, my lords, have now been thrown aside, and we have a section, section 25, which can be exercised by reference to the core values of the equitable jurisdiction, which is the power to grant injunctive relief by reference to the lodestars of justice and convenience, without having to jump over elaborate or EU-made tests. And it is clear, if I am right on that, that the judge went wrong, and I don't necessarily blame him in one sense, because the EU point wasn't available to him then, because the law remained intact until the 31st of December 2023. But he didn't take into account the submissions advanced by Mr. McGrath concerning the loosening of the shackles via convoy collateral. My lords, once the conception of the jurisdiction is clearly and accurately framed, then we can return to my skeleton argument at paragraph 137, tab 3, my lords, paragraph, page 53. First of all, at para 136, we explain how the judge went wrong in applying Van Uden. I don't criticise that for the reasons but the law has moved on. We do criticise the failure to take into account broad idea, or convoy collateral, I should say, which we spent some time making submissions on earlier in our skeleton argument. But once the old shackles have been thrown aside, we are freed to look at the actual case for what it is. And we set out respectfully before this court 6 considerations or submissions, which we say point strongly to the exercise of this power by this court, and I don't propose to lay them out paragraph by paragraph to your lordships. I invite your lordships respectfully to have regard to those to those sections or those paragraphs, which we say lead ineluctably to the conclusion. And your lordships should be free to make your own decision on this, given the errors of analysis which we respectfully suggest infect the judgment below. And we suggest that this is a prime case for this court to come to the assistance of the Scottish court and to exercise its undoubted extraterritorial jurisdiction, where the Scottish court, for perhaps historical reasons, have felt inhibited from doing so, not because they necessarily don't want to do it, but because there may be the old shackles remain. Who knows? We don't know. We have Mr. Brown's uncontested opinion, which my lords have referred to. Before I leave this topic and move on, my lords, I wanted to note certain submissions made by my learned friends in their skeleton argument. That, I think, is at tab 6 of my lord's core bundle. And perhaps we can go to page 110 of my learned friend's skeleton argument. I'm not going to go through everything. I will just deal with this as quickly as I can. At paragraph 134 of my learned friend's skeleton argument, my learned friends accept that section 25 was enacted for the purposes of compliance with the UK's EC obligations. They refer to Van Uden. And the point we make is, well, but Van Uden has gone. It's gone from this court's jurisprudence. And it's gone because of parliamentary intervention. And if we go to paragraph 135, and of course the decision, I should say before we go over, the decision of Mr. Justice Popwell, which is cited at 134(2), where the test is laid out, it's laid out in other cases as well, I should say, of the requirement for a real connecting link. But that test was overtly adumbrated by his lordship because he conceived that he was bound by Van Uden, ditto many other eminent judges who have written judgments in a similar in this area. Paragraph 135. Once it is understood, say my learned friends, that the requirement for a real connecting link has always applied to cases both within and without the Brussels-Lugano regime, the significance of Brexit falls away. Section 25 was enacted in order to bring into effect EU rules. It has been interpreted by reference to Van Uden. Van Uden is no longer part of the jurisprudence of this country and this jurisdiction. And it is then said, Section 25 is enacted for the purpose of compliance with the UK's EC treaty obligations, that's correct. It is therefore, and then this point is made about the meaning of the 2018 Act. It is therefore EU-derived domestic legislation under the terms of Section 2. Now, I think all that Section 2 says is that EU-derived legislation isn't automatically disapplied. No one's suggesting that Section 25 has magically left the statute book as from the date of the 2018 Act coming into force. What we are saying is it remains on the statute book, alive and kicking, but in fact more than alive and kicking than ever before. It remains the law. What's gone are the ECJ's overlay and indeed the common law's misconception, as I've said, as regards the jurisdiction to grant freezing orders, or injunctions rather. So that's what I say about paragraph 135. it is then said at 136, oh well, what's the difference between granting an injunction to help a court in Dublin and to grant an injunction to help a court in Belfast or Edinburgh, as we are now? Well, my lords, we say there's a world of difference, so far as it's necessary at all to make this point, or we say it's not necessary, but I still make the point. There's a world of difference between one court in Edinburgh who takes the view that this is a proper case for a freezing order, but makes the freezing order subject to the conventions of that jurisdiction so as to make it territorial alone, but still takes the view that an injunction should issue against these very defendants, these very respondents, takes the view that an injunction should issue against those respondents, but not outside the jurisdiction for historical reasons. We say there's every difference in the world between Dublin and Edinburgh, because this court, part of this one single sovereign state, I made that point, I'm not going to make it any more. Of course this court should come in and assist its Scottish sibling judges. Why not? One just asks the question, what makes it, to use the statutory wording, inexpedient for this court in England to issue an injunction supporting its sibling judges in Edinburgh? And I've not heard any answers to that, frankly. In my learned friends' submissions below, in their skeleton argument below, or their skeleton argument, what makes it inexpedient? This Lord Sanderson is not concerned about it. He's not said, I'm very concerned to see that an injunction is obtained in London. What on earth's going on? He knows all about it. He's even granted an order allowing documents before your lordships, as your lordships know. If he was concerned about it, then he would have said, no, I'm not going to make that order. I'm not going to lend assistance to a trespasser court in London.
Well, that's a bad point, if I may say so. The poor old judge is being visited by this case 6 times, did you say? He's got more important things to do than be worrying about us.
My lord, I will leave that point where it.
I think we need to move on.
We do. I'm now. I think I've made I want to make one final point before I move on to full and frank disclosure, which is paragraph 137(1). A point is made by reference to some of the old authorities that you shouldn't go granting injunctions which can't be enforced. And what is said by my learned friends is, well, Mr. Gollitz lives in Frankfurt, or wherever he lives in Germany. VDHAG is in Germany. He has limited connections with England. Although we know Mr. Gollitz comes to London, and no doubt business requires him to do so. We know that the VDH group has connections with England. That's all laid out in the evidence. But the point is made, well, you can't enforce the WFO. The court should not act in vain. Now, I'm not aware that Mr. Gollitz or VDHAG have taken any steps in the last 8 months to breach this order. They plainly treat it with respect because they've participated in this appeal, they've participated below. They didn't think, well, we don't care about an injunction against us, it's not going to affect us in any way. They've participated. They obviously treat these injunctions as not simply bits of paper to be put aside. It's obvious that these injunctions have material effect on them and are not things writ in water vis-a-vis these respondents. And it's highly unlikely that professional financial entities or men would breach an injunction of this court. So that, with respect, is I would suggest, not a point that should carry any weight with your lordships. I turn to full and frank disclosure. Now, it's right to say that Mr. McGrath had conceded before Mr. Tinkler that there had been certain immaterial, as he put it, breaches of the duty of full and frank disclosure. He nonetheless tendered apologies for those immaterial breaches, and they are identified where those concessions were made from paragraph 76 onwards of Mr. McGrath's skeleton below. For your lordship's note, that skeleton is tab 121 of the supplemental bundle from page 2645 onwards. The judge below, as your lordships will have seen, spent the bulk of his judgment not dealing with the question of expediency, but dealing with the question of breach of full and frank disclosure. And I'm going to take your lordships through the way the judge dealt with it, because it was a somewhat heterodox approach in my respectful submission. Now, if we turn to the judgment, I think it's tab 10 of your Lordship's core bundle.
Kicks off at 154.
My Lord has it. My Lord has it. And he, in a way that is consistent with his practice throughout this judgment, he makes reference to the well-known decision of Mrs. Justice Carr, as she then was in Tugashev. He contents himself with a essentially one paragraph analysis of the law, and then refers in paragraph 73 to the way he should go about considering things, and then launches in at para 74 and following to a tour of the transcript at first instance, going through every error he can find. And I'm going to spend some time on that approach. But before I do so, I'm going to spend some time without taking your lordships to any of the authorities, because they are so well known to this court. And indeed, a judgment of Lord Justice Males is recited in our skeleton argument with the greatest respect in the case of Dermamet. So I don't need to take any of your lordships, of course, to the law. It is right that Tugashev is a judgment that has been accorded, as one might expect, great respect since it was issued a few years ago. And the judgment, the sections are, or the principles are laid out at paragraph 7 of that judgment. And the critical point, we say, that emerges from that judgment, and I don't take your lordships to it in the interest of time, but I don't need to anyway, is subparagraph Roman 12, where her ladyship made clear that the overriding consideration, whenever you consider questions of full and frank disclosure, will always be the interests of justice. And my Lord, Lord Justice Males, in a decision of this year, as I read it, and I don't wish to place words in my Lord's mouth, who knows the case so much better than I do, my Lord adopted that and moved, not necessarily moved it forward, but reasserted the primacy, I respectfully suggest, of that overriding question. Where do the interests of justice lie? And we respectfully suggest that his lordship below paid no regard to that and showed no understanding, we respectfully suggest, of that overriding principle. The second point that I make in terms of the law is, which I don't take the court to because it's too well known, is that of course the court is not to engage in a mini trial of questions of disputed fact when deciding whether or not there has been a material non-disclosure. The third point I make about the law is that it is not the law that any factual error made by the deponent of an affidavit or counsel on his or her feet before the ex parte judge ipso facto leads to the set aside of the order. The question is always materiality. We get that from Tugashev 7, Roman 1, Roman 5, Roman 6. And the question posed by her ladyship, and I think repeated by his lordship, is, has the court been materially misled? And we will respectfully suggest again, and we'll see this when we go through some of the instances, that the judge did not direct his mind to that critical question whether Mr. Justice Lavender had been, quotes, materially misled by any of the evidence or any of the submissions that were made before him. The next principle, which I take quickly, is that, of course, the court, even if it takes the view that there has been a material breach of the duty, has a jurisdiction to re-grant the relief, even if it sets aside the original order. Tugashev 7, Roman 12, and indeed a case called Sibir, paragraph 1029 in your Lordship's bundle at tab 26, which I don't take your Lordships to. And again, it's not at all clear that his Lordship below properly understood that even if he made findings of material misleading, that he still retained a jurisdiction to be exercised in the interests of justice as to whether or not to reimpose the order. And of course, an aspect of that, which I think was repeated by my Lord Justice Males in Dermamed, is that there is a wide variety of remedial responses available to the court if it takes the view that there has been a breach of the duty of full and frank disclosure. It's not simply reach for the discharge, get out of court, all orders discharged forever. That's not the only option available to a judge. One option, of course, is to make swinging costs orders against the party that has been held to have breached the order, the duty, I should say. The next principle is the courts have become more and more aware of the torrential form of litigation invoked almost universally, in my own experience, by respondents who are the subject of ex parte orders. I don't think I've ever seen a case where an ex parte order has been granted where the respondents have not cried foul and set out hunting down as many breaches as they can and laying them all out in laundry lists before the inter partes judge at the return date. And of course, judges over the years have issued cri de coeur, if I can use that phrase, warning against and imploring respondents to show discretion and to show a degree of circumspection before it all pours out. Breach A, breach Z, breach ZZ, and so on and so on. And indeed, my Lord, Mr. McGrath, in his skeleton argument at paragraph 72, supplemental 121, page 2645, quotes a famous dictum of Lord Justice Slade in Brink's Mat to that effect. And that was a long time ago, and my word, things have not got any better since. They've got, if my own experience is anything to go by, considerably worse. My Lords, the last point is a decision of Mr. Justice Pickett in Tatneft, which we've already thought about in another context, which is tab 37 of the authorities bundle, I don't go to it, where his lordship took the view that a failure to point out weaknesses in a claimant's case would not generally be sufficient to warrant the discharge of a freezing order. And a false conception of how strong your case is cannot in and of itself be a ground for discharge. My Lord, I say no more about the law. We've seen how his lordship, if your lordships have pages 154 and 155 open, how his lordship set down the law in relatively perfunctory terms at paragraph 72. He then set out at paragraph 74 the way he was going to go about things. The most appropriate way for me to set this out is to go through the transcript of the hearing before Lavender J and identify all the significant parts of that hearing. And he goes so far as to say, we see that very few points were fairly and fully put to him. And I, with respect, vigorously take issue with respect with that statement. And then what he does, he picks up the transcript and goes through it, paragraph by, or page by page. And my lords, we refer in our skeleton argument to a decision of Mr. Justice Kerr in BP Petroleum from the 1970, I do apologise.
BP and Bunker Hunt.
BP Petroleum and Hunt, exactly right. Where his lordship took the view that the judge below, or an earlier judge, had, or rather, sorry, that's wrong. What he did was deprecate a approach to an ex parte order, whereby one treats it like a bit of homework. and the judge marks it and hunts through everything to try and wheedle out errors here, mistakes there, and creates a sort of charge list against the ex parte applicant. And we respectfully suggest that what has happened here in this case is that his lordship below has done precisely that. He has tried to hunt out as many errors as he can in order to effectively allow him to discharge the order. And we can pick it up, my lords, at paragraph 76, where he starts with his, para 75, where he starts with his charge list against my clients. Before I do that, can I just advert for a second to Lord Sanderson's judgment in Scotland? Now, many of the points raised by my learned friends below are the same as the points raised by the 4 defendants in April 2024 when seeking to discharge the search order and the freezing order. I'm using those phrases loosely, of course. Yeah. And Lord Sanderson went through them, and I'm not going to go through it with your lordship, but went through them, and they show great similarities between the two jurisdictions. And he went through them, and he said, really, a lot of these are very tangential, they didn't affect my thinking, they are by the by, and I'm going to maintain my order. And one just asked this question, that where an ex parte order in Scotland has been challenged, at least in part, on full and frank disclosure grounds, but has been maintained, and part of that order applies to my learned friends' clients, even if in practice it doesn't because they don't have assets within the jurisdiction. One might ask, should not the English court, I understand that information wasn't available to them, to Mr. Tinkler in December, show some respect for and consideration for the fact that the court of original jurisdiction in Scotland has decided to uphold ex parte orders. After all, this order back in London is sought merely, as I've said before, subordinately to the orders and the jurisdiction and the claim brought in England, in Scotland. And I do.
The practical difficulty with that is that you would then have to embark on a close analysis of precisely what was argued before the judge.
I understand that. I understand that, but
and you would end up. I mean, with great respect, this case is complicated enough. I've already scheduled out the full and frank disclosure allegations, cross-referring them to the transcript, the skeletons, and all the rest of it. I'm slightly loath to then do another exercise which cross-refers it again to Lord Sanderson's analysis, in a case where these defendants, for whatever reason, were not present. Aren't we better off?
Well, I'm not going to spend much time on this. I'm merely pointing out that Lord Sanderson had a number of the same points raised with him and took the view that they were really by the by and did not in any way impeach his original judgment. I'm not going to say anything. I hear, my lord, and I will proceed accordingly. Paragraph 75, my lord, is the starting point. And we can just see that the judge's approach in action. Come across these, perhaps we should have the transcript also in front of us at the same time. My lord, the transcript is right at the end of my lord's transcript. This is the transcript, so it's not right at the end. The transcript of Mr. Fennells's submissions, and that transcript is, I'm just going to get the reference from Mr. Wright. It is tab 95, page 1888. Forgive me. So that's the transcripts from 20th of October. Mr. Fennell's KC leading Mr. Robb appeared in London. So 1889, my lord, and I think we start at page 190 is page 6 of the transcript in the bottom left quadrant. So What is first said against my clients is, well, paragraph 6, Mr. Fennels refers to a letter from Gollitz, who's said to be one of the Luxembourg directors. He, of course, was not, because he was a director of the German company, not the Luxembourg company. He'd never been a director of any Luxembourg company. That was actually wrong. He had been a director of VDHI some years earlier. So the judge, in his haste to criticise my clients, overlooked that. But he then says, one of the themes that arises throughout this document, the skeleton argument and the affidavit of Yahya Tahir, which is the affidavit which founded the ex parte application, is this continual and systematic conflation of the various defendants, of the various VDH defendants. My lord, the simple point there, which the judge just simply ignored, is that Mr. Tahir's affidavit at paragraph 15, which is page 1830 of the supplemental bundle, had made clear that Gollitz was only a director of the German company. It was a slip of the tongue, if anything at all, by Mr. Fennels KC, which cannot have misled Mr. Justice Lavender, given that he no doubt would have read the foundational affidavit of Mr. Yahya Tahir. So that's the first point. The second point is the wider question of the interconnection between the VDH parties is hotly disputed within the proceedings. And Mr. Nasser Tahir, in his own affidavit, spends literally pages upon pages talking about the interconnection between VDHI and VDHAG. So it's just a false and unfair criticism, given that that's part of our case, that they are intimately bound up with each other, these two companies, the Luxembourg and the German company, at the time, of course, sharing, broadly speaking, a common owner. And the fact that they were separate legal entities was properly presented to the court. It was properly presented in Yahya Tahir's affidavit. The one mistake that Mr. Fennels made, which was entirely an irrelevant mistake, it didn't have any material impact on anything, was to refer to Gollitz as one of the Luxembourg directors. But instead of making those points and putting Mr. Fennels' minor slip of the tongue into context, instead the judge zones in on that and ignores what was said in the affidavit and ignores the fact of the common ownership. 76. Lavender J was told, this is of the judgment, that multi-bank group is regulated in a large number of jurisdictions and so far has a blameless reputation in the industry. Now that was a statement made by Mr. Fennels, and it was founded upon evidence of Mr. Yahya Tahir at paragraph 19 and 44.1.3, supplemental bundle pages 1832 and 1843, where Yahya Tahir goes through all the jurisdictions in which the claimant company is regulated, not including London, England, and says we're regulated by I don't know whether it's the Malaysian, I'm just using various phrases, Malaysia, Abu Dhabi, Dubai, or whatever, and we are entirely regulatorily blameless in those jurisdictions. He doesn't mention London because we're not regulated in England. And any reference or understanding of that submission surely should have been, we're now at page 7 of the transcript, was understood by Mr. Justice Lavender, no doubt in the context of the evidence that was actually placed before him, which the judge again ignores. And instead he says, aha, they're actually on an FCA watch list, and refers to the website, which your lordships have heard about in terms of the Land and Marshal jurisdiction, maybe providing financial service or products without our authorisation. And then says this, which is an entirely unfair supposition. This cannot in any sensible view be viewed as a blameless reputation in the industry. The FCA, your lordships have evidence about this, which I'm not going to go through. The FCA watch list makes no findings or regulatory impositions on my client whatsoever. It's not regulated by the FCA. And if one looks at the evidence which has been set out in the Ladder Marshall material, your lordships will see that it was entirely proper for Mr. Reynolds to make the submission that he made, and it was quite wrong, with respect, for the judge to hunt down another supposed breach to add to his charge sheet. Your lordships have the website in your lordships bundle, and it does not in any way impeach the blameless reputation of my clients. And indeed, Ms. Wright put in evidence at the time explaining what might have happened. And my lord, then Mr. Tinkler then says this: Lavender J was not told of this fact, which was plainly known to the claimant. Not one shred of evidence that it was plainly known to the claimant. Why should my clients know that in respect of a jurisdiction on which it doesn't operate, the FCA had whacked on the website these opaque words? They're not hunting down, let's see what the Argentinian FCA has to say about us daily. Let's see what the Ecuadorian FCA has to say about us daily. That was an entirely false statement with respect, plainly known to the claimant, and gratuitously false as well in my respectful submission. In any event, how is it going to affect any decision made by Mr. Justice Lavender, that submission? Again, not in any way explained by his lordship. And I know I shouldn't do this, but Lord Sanderson dismissed a similar criticism in his own judgment. Now, that's the last time I'm going to mention Lord Sanderson, I should say. My lords, we carry on in this charge sheet to paragraphs 78 and 79. Over the page 156. This is a tiresome exercise. I'm quite cognizant of that fact, but I'm afraid I'm bound to go through it, given the way that Mr. Tinkler decided to go through it. He then sets out various statements of judges from 20 or so years ago. The statement of Mr. Justice Stanley Burton at 78-1 is from a judgment made in 2004. 2004. The finding of contempt, which was made in, I think, in 2008, 16 years ago, is a finding which was, as I don't believe his lordship even deigns to refer to, the subject of an appeal. One of the Lord Justices stayed the order pending appeal, and the order was set aside on appeal by agreement. Supplemental bundle, tab 3, page 37. And yet it is said that it was a material breach of my client's duty that they didn't bring to Mr. Justice Lavender's attention, that 16 years ago, Mr. Nasser Tahir, not a litigant before the claimant, the court, claimant is only MGWL, had been subject to a finding of contempt that had been set aside. There was no duty whatsoever on my client to refer to such extraneous and irrelevant questions. And again, not one hint about how that is material from his lordship. And one asks, how would it have affected, what would Mr. Justice Lavender have done with that information? How would it have affected the jurisdiction that he exercised, even had he been told it? And I should say Mr. Nasser here gives evidence about that in his own affidavit, paras 149 to 150, supplemental bundle 2215 to 2216. The next criticism on the charge sheet, paragraph 80. Page 11 of the transcript, at the bottom of that page, Lavender J is told that some adverse findings made against the claimant at an interim stage, and to the extent that those adverse findings were made, they were in effect reversed by the Court of Appeal. Now, that relates to the BVI proceedings. And again, the judge does not refer to the fact that there was affidavit evidence on this before Mr. Justice Lavender, which no doubt he read. It was the central affidavit, where Mr. Yahya Tahir refers to the fact from paragraphs 86 onward of his first affidavit, page 1867 of the supplemental bundle, he refers to the BVI proceedings, and he refers to the allegations made against MBFX and Mr. Tahir by VDHI in those proceedings, paragraphs 88. And he refers to the fact that there is a freezing order made and not discharged against MBFX and Mr. Tahir. So it is quite obvious to Mr. Justice Lavender that there is a freezing order in BVI against those two entities, not the same entity as MGWL. And Mr. Fennels was entirely right in what he said. The Court of Appeal took a very strong view about the way that Mr. Justice Jack had gone quite outside his jurisdiction, and that's why they took the exceptional step, a very rare step, as your lordships don't need me to tell you, to recuse this judge, Mr. Justice Jack, from any further involvement in this case. The point is covered in the skeleton, para 16 onwards, the ex parte skeleton, page 1782. Again, not mentioned.
What's the reference?
Page 1782, paragraph 16 of the ex parte skeleton.
1782.
Thank you, my lord. I'm so sorry to be giving you so many numbers. Not referred to. Not referred. Sorry.
What did that say?
Well, let's go straight to it. It's bundle 2 of the 1782 tab number 91. Yeah, it's paragraphs 14 through to 16, my lord. And the affidavit, my lord, before Lavender J, makes it clear that there's a freezing order against Mr. MBFX and Mr. Tahir. So obviously there was findings sufficient to justify a freezing order in the BVI, which continued. There may have been some marginally loose language of Mr. Fennels, but it cannot conceivably have misled Mr. Justice Lavender, who no doubt read the affidavit and the skeleton argument. And again, it's an example, if I may respectfully suggest, of the judge hunting down marginal errors of Mr. Fennels without actually putting in the context of all the information that was available to his lordship. And in any event, where does it go? What's the materiality? Given we're talking about not even the proceedings in Scotland, we're talking about tangential proceedings in the BVI between different parties. VDHAG is not a party, Mr. Gollitz is not a party, MGWL is not a party, or rather they're a party, those two are parties in the marginal sense of having challenged jurisdiction and making no actual allegations themselves. My lord, I move on. Page 157, paragraph 82. Mr. Fennels tells Lavender J on page 16 there is a certain opaque quality to the Luxembourg companies. Now, and then at para 83, your lordships can read the criticism that flows from that. General attempt to conflate the 4th, 9th and 10th defenders and create an image of underlying dishonesty and subterfuge because Mr. Fennels said a certain opaque quality. Right, it's necessary to actually look at what Mr. Fennels said here because it just calls the lie, explodes rather, sorry, I shouldn't use that phrase, explodes the conception that the judge has. If your lordships go to page 1892, and we see, and we're in page 16, bottom right-hand quadrant, where he talks about a certain opaque quality. The actual context of Mr. Fennels' entirely accurate statement is the circumstances in which Mr. Smith became the day jury manager, not of VDHI, the Luxembourg company, but Mex Securities. What Mr. Fennells is saying is, in the context of what was happening in mid-December 2020, when your lordship's heard something about this, Volotovsky was the manager or not the manager, then he was changing to Smith, and the question of authority, and when precisely did Smith become the day jury manager as opposed to the de facto manager. And Mr. Fennells is saying, oh, there's a certain opaque quality to the Luxembourg companies in that context. It's an entirely false criticism. And it just shows your lordships, I respectfully suggest, quite how the judge has gone wrong in his prosecutorial approach. Just wrong, paragraph 83. And then paragraph 84, the non-separation of the parties continues on page 23 of the transcript. And we have what is described as the VDH parties. I mean, this one looks at paragraph 23 to see what Mr. Fennells allegedly did wrong. And it's line 11 and 12. The links to Duffy are set out. In the third group, we have the VDH parties. What actually Mr. Fennells is talking about at the moment is he's talking about the various groupings of the defendants by reference to his skeleton argument, and he uses a shorthand for Mr. Gollett's VDHI and VDHAG as the VDH parties. And apparently that's a breach of the duty of full and frank disclosure. I mean, it's just nonsensical with the greatest respect to the judge. Right, let's move on. Paragraph 85 in the charge sheet. We then turn to one of the core matters that Lavender J identified. At the bottom of page 27 to the top of page 28, this is of Mr. Fennells' submissions. He asks about the bribes that were said to have been paid. Mr. Fennells says that the terms of the consent order, and then he quotes from it. Now, the judge seems to think, the judge below seems to have thought that Mr. Justice Lavender was misled as to the bribes or inducements that had been paid. Now, your lordships may recall that part of the pleaded case in Scotland is that CSM had paid to it over a number of years, from 2021 onwards, a large sum of money via VDHAG. And part of the pleaded case is that those payments were a form of inducement to CSM in order to persuade Mr. Smith to play ball with the resiling and the renunciation of the settlement agreement. And the idea that Mr. Justice Lavender was misled into thinking that somehow some of the money kept in Mex Securities for the purposes of funding the proposed litigation against VDHAG was the same as the money paid over by way of inducement or bribe, as pleaded in Scotland, to CSM. It just isn't to be borne. It's just obviously not right. Mr. Yahya Tahir makes very clear in his affidavit 1, paras 45.1.3 and para 130.
You have to slow down when you
I do apologise.
Yahya Touré's, sorry,
Yahya Tahir,
easy
AF,
mistake.
no, quite right. AF1, 45.1.3 and paragraph 30, pages 1851 and 1877. I'm sorry, I'm not going to use that phrase. I don't need to take your lordship to it. The notion that Mr. Justice Lavender was sort of misled or misunderstood these two sums of money is just obviously wrong if one actually reads the material before Mr. Justice Lavender. The money paid to CSM by VDHAG has obviously got nothing at all to do with the money kept in Mex Securities. It is money...
What Mr. Yahya Tahir is talking about at 45.13.
45.1.3.
45.13 is the €7 million that was left with Mex Securities to fund the claim against VDHAG.
Yes, forgive me, I'm going to turn to it because I don't want to give you I don't want to just agree with your lordship, although I'm sure I do agree with your lordship.
Page 1851.
Thank you, my lord. 45.1. What page is it?
1851.
Thank you, my lord.
Top of the page. We eventually agreed to leave about circa 7 million euros with Mex Securities for the purpose of funding
Right,
the claims.
it's got literally nothing to do with the monies subsequently paid over by VDHAG, ostensibly by way of funding of investment into CSM, which of course is an aspect of the general claim in conspiracy against these defendants, that they paid in large sums into CSM. A point that I should have given probably greater prominence to, but didn't do so. But it's in my skeleton argument. It's in the affidavits. But it's a fundamental aspect of the claim against the various defendants that CSM was the recipient of very substantial sums of money via VDHAG and that is pleaded out. My lord, but the criticism made at 85 is just so unfair to Mr. Fennels. I speak with perhaps some fellow feeling to the former chairman of the bar.
So why, when he is asked about the bribe, does he start talking about the money that's going to be left to fund?
My lord,
is it just that he is confused?
I think that might. I just don't know. Is the answer. I don't have an affidavit from Mr. I don't have an affidavit from Mr. Fennels, but it is. But Mr. Justice Lavender, the point I'm trying to make is that Mr. Justice Lavender has presumably read the affidavits. He's presumably read the skeleton argument. It's quite obvious from the affidavits, that the two sums of money have entirely different meanings and purposes in this claim. And I'm not sure, even if there was a confusion, where it actually went in terms of undermining how it went in terms of materiality. My lord, I have to move on.
Accept that bribes is an important matter in these sorts of applications.
It is, but it remains
vital in these sorts of applications.
Your lordship's absolutely right, but the underlying point about bribes remains absolutely intact. Absolutely intact. Because it is undoubtedly the case, no one disputes this, that in fact the sum that's been received by CSM, this company apparently headed up by Mr. Smith, my client's myrmidon, apparently on my learned friend's case, has received in fact, more than 7 million by common ground. It is 8.6 million euros over a period, as we got the numbers in the files, over a period of 2 years or so, 2.5 years. And there were monies being paid in from February 2021. And of course, one of the great questions, I'm sorry to go back because my lord quite rightly raised the point. One of the great questions in this case, which is no explanations of an adequate nature ever been tendered, is why on earth does Mr. Gollitz, his case is Smith is a fraudster. He sits down in the proverbial smoke-filled room in Dubai and hatches a plot to nick 36 million euros. And Smith's part of that plot. That's Mr. Gollitz's own case and evidence.
The 7 million that was left with Mex Securities, that's referred to in the transcript and
yes.
referred to in paragraph 45.13 of the affidavit, is clearly different money from the money that's said to be some sort of bribe.
Wholly right.
Because what happens if you look at the transcript at page 1896, there does seem to have been some confusion during the exchange between Mr. Fennels and the judge.
Yes.
Immediately before the lunch break.
Yes.
Which is at the bottom of page 29. There's then a break of an hour, and it's quite clear that Mr. Fennels has got his artillery into some sort of order. Because what he then does, he takes the judge to paragraph 130 of Mr. Tyer's affidavit,
precisely right,
which is at page 1877, where Mr. Tyer talks about the 3.6 million and the 3.4 million, and that's the 7 million that had gone to CSM, and that's what he says is that's he says at the top of page 31. That's where the figure of 7 million comes from, my lord, and it's that money which by inference had no good reason to be going to CSM.
Precisely.
So on the face of the affidavit and the subsequent explanation, it's a bit difficult to see how the deputy judge could have been right that Mr. Justice Lavender was somehow misled into thinking that this was all one and the same 7 million.
My
It's
lord,
pretty obvious that he can't have been.
yeah, well, that's my submission, and it feeds into a wider, broader point, which is that this deputy judge, this learned deputy judge, Mr. Tinkler, has effectively set himself a prosecutorial role to go through poor Mr. Fennell's submissions and eke out and hunt down every infelicity. And my word, if we were all judged according to those standards, who would escape whipping?
Well, presumably he did all this because Mr. Cafflon invited him to, Mr. Cafflon invited him to.
Well, I suspect that's so.
I mean, I imagine, I'm not criticising you, but I mean, the judge did this because these are the submissions that you made, presumably.
My lord, yes, and I'll come to that.
Of course.
Yes.
We didn't sort of
No.
bring them up from nowhere.
No.
My lord, let me move
Mr.
on.
Grant, he can't have gone through the transcript to do that, can he? Because he did it, this is an extemporary judgment. I appreciate that there were changes made, but this was an extemporary judgment.
He had within the bundle the transcript, which is at page 1896 of the volume 2. So we had the actual transcript of what Mr. Fennells was saying to Mr. Justice Lavender. That was in the bundle. The judge, that is Mr. Tinkler, receives the submissions,
I understand, yeah.
and he then sits down on Friday, the 15th of December, having reserved judgment for 3 working hours, and comes into court,
And gives an extemporary judgment.
gives an extemporary judgment, and then he's
So
pouring.
you say this is marking the homework.
Exactly.
Yeah, okay.
Let me move on.
Right.
Paragraph 90 of this judgment, page 158 now of the core bundle.
Well, 90 and 91 are more Gullett's VDH, aren't they? Conflation, blah, blah, blah.
Your Lordship's right. Your Lordship's right. But the point is that if one reads the Yahya Tahir affidavit in a fair way, there's no possible ground for thinking that Golitz is an employee or director of VDHI. His involvement in the Luxembourg companies, insofar as it's suggested, is suggested on the basis of A, his involvement in CSM, which you've heard a lot about, as well as the fact that VDHAG is the investment manager of VDHI. It takes decisions on behalf of VDHI. Mr. Priest puts in evidence that essentially he's a passive party, he's the custodian, but VDHAG is the active party actually making investment decisions. So it's perfectly proper to talk about Mr. Gollitz's involvement in Luxembourg companies. And in any event, so what? Where's the materiality? We're not told. The judge just goes on, cross against the homework, let's move on, follow the class.
Right. Okay, I think we've got those points.
My lord has.
Let's move on to something.
91.
That doesn't seem to go anywhere.
I don't think that goes anywhere.
No, well then 92 and 93. Let me just look at my notes to see if I can get this.
92, 93 is the let go point.
The let go point.
I mean, really, Mr. Yahya Tahir had given.
Speaking for myself, I doubt whether this case is going to turn on the let go point,
Well,
No,
but
I-
my lords may take a different view.
we take a break.
my lord makes that point, and I join in your lordship's humour. But it's not funny from my client's
I
point of
know,
view.
we're not suggesting it is.
No,
Mr.
I'm not
Brown.
criticising the court for
A
laughing.
measure of,
But
of
Mr.
proportion.
Calfon stands up with a straight face before Mr. Tinkler and says, discharge this order, not for various reasons.
But if he'd done it in front of either of us, he would have got pretty short shrift.
Yeah.
I think is what my lord's saying, and
Well,
I tend to agree. So I'm not sure.
I'm not going to.
to necessarily let. I mean, if Mr. Calfon wants to come back to the let go point, there's something for you to say thereafter. Fine, but
I'll move on.
there are more important points.
No, I quite understand, my lord, and I should say I wasn't criticising humour from the bench. I was joining in it, and I
Not
agree with it.
suggesting-
But
not
it's
suggesting
the disjunction between the absurdity of the point, I would respectfully suggest, and the fact that it's led to the outcome which has which it has caused, and that's the disjunction.
Okay.
My lord, I move on. I know it's tiresome and boring, this process. Paragraph 94, page 159. I mean, it's almost like a tit for tat. Well, why don't you mention that that the only party in these proceedings with a history of non-compliance is Mr. Tahir? I mean, it's like a sort of game in a playground, that paragraph 94. I mean, I'm sorry to be able to have to say it that way. Paragraph 94, I mean, I'm not sure that was Mr. Calford's point, perhaps it wasn't. 95, this is K2. Then a suggestion that Mr. Fennels was at fault for not saying, aha, be warned, Mr. Justice Lavender, K2 is not a court-ordered expert, but an entity we've retained ourselves. It was not, the report was not created, line 3, for the purpose of creating an objective assessment of the situation of the defendants. Well, A, that's wholly unfair. K2 are a professional organisation. They're not going to twist the facts. But B, it's obvious, one assumes to Mr. Justice Lavender, that they're not some kind of court-ordered expert. They've actually been retained by their client. And then there's a broad point about, oh, well, you know, when did we learn about some aspects of this case and so on. I think this may be taken a bit further on in the judgment. The timing question in this case had literally nothing to do, obviously, with when we discovered fact A or fact B or fact C. The fact that we were urging this application and moving it on the 20th of October was a pure function of the fact that we'd sought ex parte orders 2 days earlier in Scotland. And I'm not sure the learned judge understood that point. It's not no one was suggesting if you don't make the order now, the ship is going to leave the dock, or the money is going to leave the UK bank account at 1 p.m. Please intervene now. No one suggested that the question of urgency was dictated by that. The question was, we've got an order in Scotland now, and in order to make this order effective, we need to get it now rather than in a week's time or 3 weeks' time after we've served the orders in Scotland. My lords, so just keeping on paragraph 95, Mr. Fennels is actually showing the judge paragraph 63 and 64 of his skeleton, page 1804 and 1805 of the bundle. And if one looks at those skeletons, I'm not going to look at them now, there's literally nothing inaccurate or wrong. And we see the criticisms of para 95 are just simply wrong, with the greatest respect. 96 and 97, I move on. This is finally, my clients are exonerated at 96 and 97, so I can move on from that. 98, there's a reference at the bottom of paragraph, page 40, to VDHI having bonds issued by an English company that VDH is inherently likely to hold English assets. The claimant presents this as a connection to England. That description, of course, fails to mention that the assets held by the 10th defendant were not its own assets. Now, that's a contentious question, my lord, because there's a very substantial amount of evidence as to how Luxembourg entities hold their assets and whether or not they are held beneficially for English terms beneficiaries, or they are held subject to contractual obligations only. It's a matter of dispute. And a point made by Mr. Fennels himself at page 43 of the transcript, if the judge had read on. And in any event, these are references to the ex parte skeleton argument at paragraph 75, Mr. Yahya Tahir's affidavit at paragraph 142 and 147, which set it all out. Nothing incorrect in those paragraphs. Judge doesn't look at those paragraphs. I move on. Paragraph 99. This is the urgency point. Again, I've made the submissions about urgency, and the judge doesn't then read on, because Mr. Fennels himself then refers the judge to section R of the Yahya Affidavit 1, page 1182, which explains the reason for going now, 20th of October, is linked up with the decision to seek the order in Scotland 2 days earlier. Mr. Fiddles makes that point further on in the transcript. We then go over the page. Well, I think I've
Yeah.
what we see, broadly speaking, in those paragraphs is a misunderstanding and a fundamental misunderstanding of the question of urgency. And I don't think I need to say anything more
No.
about that. My lords, there's then a long, it's tiresome to say it, I'm almost hesitant to say it. There's then another yet further points, which I'm going to try and go through even as quickly as I can. Paragraph 105. We now, the charge, the eye of Sauron is now moving from the transcript to the skeleton argument. I'll be brief to avoid repetition, para 105. Paragraph 10, the claimant says it only recently became aware and obtained evidence in relation to the unlawful means conspiracy. That is said to be untrue. The fact is, as set out in Mr. Yahya Tahir's affidavit, they were building up their case over time. Certain facts slotted in various places. But so what? So what? This is not an injunction which is justified or not justified by reference to urgency. And my lord, the Chancellor, of course, has laid down important dicta in the Raven case on this very subject. So I'm not going to belabour the court with that. We've drawn it to the attention of the court in our skeleton argument. And indeed, I'm fearful to have to take the court to yet a further affidavit. But if one goes, as one shouldn't do now, to Ms. Wright's affidavit, which was put in response, which is an affidavit at tab 118, page 2279, Ms. Wright being the general counsel of my client. From paragraphs 52 onwards, she meets these points and explains all the facts that became clear when they became clear, to show that this was a question of piecing together the evidence over time. Paragraph 106. We're criticised for saying in our skeleton that the 10th defendant is a considerably smaller private Luxembourg entity, now no longer part of the banking group. This omits to say that it remained under the same common ownership. Well, as you might imagine,
That's plain from lots of other materials.
well, Mr. Tahir, Yahya Tahir, had emphasised the common ownership.
Yeah.
Is a rather important part of our case in his affidavit from paragraph 16.
That seems to be the opposite complaint of the previous one.
Well, exactly.
Complaint of.
Exactly. And in fact, Mr. Tahir at paragraph 24, I'm not going to take your lordship to it, had made the same point. I mean, it was no longer part of the banking group because in July 2022, or thereabouts, Mr. von Bottker, the ultimate UBO, had moved VDHI out of the group so that it became a freestanding company owned by an SPV called Cambria. And whether VDHI would be insolvent now, had it remained within the group, is an open question. But it became a freestanding, unsupported entity and is now in insolvency. 107. It is said the investment bribe is in the form of the investment in bonds, in other words, the 7 million. It does not say the bribe was not 7 million, but instead the fees CSM was earning on the investment. Well, the judge himself understood that because he said at transcript 29, line 12, at the very least, I suppose you can say that the Scottish defendants, if I can call them that, continue to profit from their relationship with VDH, including via their company CSM. The judge wasn't misled, didn't think that the 7 million euros had literally been placed in Mr. Smith's Swiss bank account.
No.
False point, yet another. 108. The fourth defendant is described as the person in practical control of VDHI. He was, of course, not. Well, in fact, our case is that he jolly well was. Mr. Price himself confirms the limited control he had over the funds managed by VDHI. Paragraph 67 of Price's affidavit, page 2029 of the bundle. we know that Gollitz had very wide powers of disposition over VDHI's managed assets. So it's just a false point with respect by the judge, 108.
I see that the defendant's application notice saying that the order should be set aside at the return date hearing before this judge says that they committed numerous breaches of duties of full and frank disclosure. Was there ever a document saying these are the failures of disclosure on which we rely? 1, 2, 3, 4, down to how.
I'm going to have to leave my learned friend Mr. Calvin to answer that question.
I'd like to see that document if it exists.
Well, I'm not answering now perhaps, but they may, I don't know the answer. I don't immediately know the answer to that question. My lord, that's 108. We're getting close.
Yeah.
109. The summary at paragraph 25 of the skeleton is in essence a summary of the contents of the K2 report. In my judgment, it makes no attempt to provide context around the history and involvement of other parties. In short, it presents a one-sided picture. It presents our case, and I don't know what the one-sided picture actually involves. And in any event, paragraph 25 is a recitation of what is stated in Yahya Tahir's affidavit 1 at paras 24 to 43.
But
As
your point about marking homework, I mean, what this demonstrates, you would say, is that this judge has gone through each individual item and looked at it in isolation
quite.
and has failed to stand back from it and say and ask himself the question, well, if I looked at that in isolation, would I say that that doesn't give the complete picture? Yes. But if I look at the totality of the
Right.
material that was before the judge, do I think that there was a misleading picture? Answer, no. And I mean, when one gets onto Mr. Yahya Tahir's affidavit and what he says about that, it seems to me a lot of that is really completely fails to spot the point that the full picture is to be derived from
Totality.
the totality, the affidavits, the skeleton arguments, the submissions made by counsel.
Well, poor Mr. Fennels is trying his best to get through an application. He knows the judge has read the affidavit and the skeleton argument, and because he doesn't say every time he makes a submission, oh, by the way, I need to take your lordships to the following 15 paragraphs of Yahya Tahir's affidavit, he's hung out to dry. It's not the way one litigates in my respectful submission or adjudicates. My lord, para 109 I've dealt with. It's merely a recitation of the very long evidence of Yahya Tahir at paras 24 to 43 of his affidavit, page 1787 of the supplemental bundle. 110, description of the losses alleged to have been suffered by the claimant. This is in the skeleton argument. The paragraphs make no reference to legal challenges arising both from reflexive loss arguments or from arguments that the claimant is not the appropriate party to bring the application. Well, I don't know what the reflective loss arguments are, and certainly Lord Sanderson doesn't appear to have been in any way troubled by them. And after all, this is a Scots claim, not an English claim, based on Scots principles of damages and loss and causation and so on. In any event, Mr. Tinkler decided that there was a good arguable case overall, including with relation to damages, para 36 of his judgment. And for what it's worth, and I'm conscious of my Lord Justice Coulson's injunctions, Lord Sanderson agrees there is a good arguable case on loss. Para 49 of his own judgment. Para 111, down the page. The other points that I've made, your Lordship, give me another 5 minutes. I know I'm trespassing on your Lordship's time, because I will in 5 minutes get to the end of this long chart. My Lord, there's an answer to your Lordship's question, which I'm not going to answer now, about the...
All right, well, somebody will tell me.
I might ask Mr. Wright to answer it, actually. So, paragraph 111, no, yet further, the joining together the 9th and 10th defendants. That's our case. We put in a massive evidence to establish that case.
It's the same point.
Yeah, it's the same point. No one's asking the court to decide it. Gollitz, as the CEO of AG, has a wide power of attorney over VDHI's assets. No one's suggesting he was a director of VDHI. There was one hint in the evidence that he was a director of VDHI. Over the page, we're almost at the end. 112.
Same point.
Same point.
Same point. Same point. 113. This isn't legal reasoning at 113. claimant set out their case.
Well, I'm not sure that's a really non-disclosure point at all, is it?
No, agreed. It's the claimant set out their case in their skeleton argument by reference to authority, and Mr. Justice, Mr. Tinkler disagreed with it.
Then he goes on to deal with Mr. Yahya Tohai's affidavit.
Yeah, we're finally getting to the end of this long slog. Briefly address, and then this is the point made here is, aha, he made a mistake by referring to Gollitz and AG as not parties to the BVI litigation because they were technically had been joined ex parte, and at the time they were challenging the jurisdiction and had taken no steps in the litigation. That was technically an error. That is to be accepted. But so what? Where does it go? Why does it matter? How's it going to affect Mr. Justice Lavender's decision one way or the other? The judge doesn't assist us on that. 115, we've had that point before. 116, it is said the deed of affirmation was signed on behalf of the VDH companies, including VDHI. It was only signed on behalf of VDHAG. I mean, the capacity in which he signed that deed of affirmation is a contested question. In any event, it's completely irrelevant. 117, I mean, we're getting to the outer reaches of irrelevance when it comes to full and frank disclosure at 117. I'm not going to discuss it any further. Then there's a sort of overarching tally up 118. Your Lordship knows what my submissions are on that. I'm not going to go through each one of paragraph 118. Yeah. My lords, in the 3 minutes that your Lordships have very kindly given me, and I'm grateful, it is quite clear that the judge made the following mistakes. Right. He doesn't look at this. He doesn't actually familiarise himself with the law as summarised in Tugashev properly. He pays lip service to it, but his observance is, he honours it, to use the time-honoured phrase, more in the breach than in the observance. He doesn't ask ever, how are these failures material? He doesn't really care, it would appear. Poor old Fennels has made another blunder, whack it in. Para 3, the next point, he never asks, in what way was the court actually misled? He never takes account of the fact that he made no finding of deliberate misleading, which of course is highly relevant to the remedial response, even if a mistake is made. He never shows the slightest sensitivity to the vitally important point in Tugashev, as endorsed by this court in Dermamed, that the overriding consideration will always be the interests of justice. That is ignored. He never shows the slightest sensitivity to the fact that there is a wide range of remedial responses available to a judge if there has been a breach of the duty, and one should look at those. He just goes straight for gold. Discharge. He doesn't ask whether the failures, if there are any, and I dispute there were at all, other than trivial ones, can be addressed in some other way. He never properly addresses the question of regrant. And that is, I think, to be found at paragraph 120, which is the final paragraph in the charge sheet. He doesn't make a decision that they were deliberate. He says this, line 3, it seems to me that the inevitable consequences of this freezing order should not be renewed. Inevitable consequence. There's no consideration of the subtle and wide-ranging considerations that need to be taken into account according to Tugashev and a host of other judgments. My lords, with that tiresome survey, probably the most tiresome hour and a half your lordships have ever been subjected to, sitting on this bench.
I'm a construction lawyer, Mr.
Well, of course I know that, but your lordships have been very, very patient, and I'm grateful for that. And those are my submissions on that third issue.
My Lords, I'm sorry to occupy further time. My Lord Justice Mayles asked for some document references. Could I just provide the references from the skeleton arguments below as regards full and frank disclosure?
Of course, thank you very much.
So the first from the HK Defendants is in supplemental bundle tab 122, page 2704, paragraphs 86 to 150.
86 to
115 or 150?
150.
I'll just check. I think it's 150. Yes.
so 64 paragraphs.
Yes, I'll just check that, my lord, if I may, just to make sure that that's right. Yes, that is correct, my lord, yes. And of VDHI, because there are obviously two skeleton arguments for the judge below, supplemental bundle, tab 123, page 2765, and somewhat less, I think, paragraphs 136 to 139.
I apologise to detain you yet further, but the answer to my Lord Justice Mail's question about the warrant of interim diligence in Scotland and whether Mr Gollett and DHCJ had notice of it. They did have notice of it. They were parties in the sense that they had the right to be heard. They were physically not in court when it was argued, but the hearing was a mixed hearing which had some procedural elements and the challenge heard across 3 days. I understand that Mr Gollett and DHCJ's leading counsel was present for the procedural elements, but they physically left court for the challenge.
My lords, I was going to make one further point, I'm sorry, which is just for tomorrow. I'm not going to ask for more time, but just in terms of the order of submissions, I was proposing to address your lordships actually first on good arguable case, because I thought that might just be a better natural order, then going on to risk of dissipation.
Well, that's fine.
Okay.
Just as long as you both realise that we've only got tomorrow.
Yes, of
and we
course.
need to finish by 4:30. We've given you 10 minutes more today. You may not get the same indulgence tomorrow.
Court rise if able.